Let me go to Mark and some of the legal aspects. Mark, there are so many legal questions here, and to the extent that you're capable of answering, let's start with Angela Corey. She initially said that she would bring this case to a grand jury.
True.
She changed her mind.
Correct. She has that discretion, and she exercised it way in the beginning of the case when everybody wanted me to have an opinion. I kept saying I'm not going to have one because I don't know the facts. And I kept saying all along, let's wait till the facts. Though she has that discretion, I do think that a more appropriate presentation would have been to a grand jury. After all, 18 people in Seminole County would have heard the evidence, would have asked whatever questions they wanted to ask. Quite honestly, Mr. Zimmerman has an opportunity to make a presentation to the grand jury, though that's the extraordinary exception to the rule. In most of my life, in a case like this, we may well have taken advantage of that. And then if a grand jury had decided yes or no, then we would have 18 people decide, not one prosecutor who may have come down here with a particular focus.
You think that there's political pressure brought to bear in this case, considering it's so high profile? Do you think they felt that they had to give in? There were a lot of conflict within the town, Sanford, the county, the area, New Black Panthers, Al Sharpton, a lot of pressure. Do you think they capitulated in any way to pressure?
I'm not certain what pressure she took on herself, but as you just said, the reality of we can't deny the fact that the social pressures that existed in this case were phenomenal, beyond belief for any other case. This was, like we said, an unfortunate event between two young men, and yet it turned out to be a case that could literally divide the nation. With that as a backdrop, the FBI got involved where they normally don't. We had protest where we normally don't. And so to suggest that any person, be it a political person or just anyone looking at a case, is not going to be aware of and most likely react to those pressures would be absurd. That would be like me saying that I'm not going to understand that I may have to be on the media. I understand that everything in this case is going to have to be under scrutiny. There's no doubt that everybody involved, from Governor Scott to Angela Corey to Norm Wolfinger to Bill Lee, to everybody who realized at some point that this case is going to be under extraordinary scrutiny and that they have to react to it.
Alan Dershowitz, not somebody that I often politically agree with, has weighed in pretty heavily on this case, and he said that Angela Corey knowingly told a false story, failed to mention George's broken nose, George's injuries, and was very outspoken about this case. Do you feel that there's been an injustice, especially if you look at the original order, which I have here in front of me? They definitively say, they didn't provide evidence, that it was George Zimmerman who confronted Martin and a struggle ensued. Police report indicated that, in fact, there's no evidence to corroborate that.
She has discretion as to how she's going to handle her job as a prosecutor. She has wide discretion.
But did she have an obligation to put in there his injuries?
I believe that a probable cause affidavit should include all the available information, not just that information which will assure an arrest or a charging. I mean, that's just, if you really think about it, take away the lawyers, take away all that. If you're going to say this person should be charged with a crime, would you want all the information available or part of it? I think everybody who answers that question is going to say, give me all the information.
Yeah, but well, and then it goes back to the question of, for example, how do you make a definitive statement? Zimmerman confronted Martin and a struggle ensued. Doesn't it have to have some evidence to back up that statement if you're going to make it in a...
It was sworn to by an officer who has to say that I believe this is true. Mm-hmm. He doesn't have any independent knowledge except that which he gets from his investigation. So you would presume that if he's going to say that statement, it is backed up by evidence. When I cross-examined one of the investigators on the bond hearing, he couldn't come up with evidence to support that.
You filed a motion and you said that the court makes gratuitous, disparaging remarks about Mr. Zimmerman's character, advocates for Mr. Zimmerman to be prosecuted for additional crimes, offers a personal opinion about the evidence for the said prosecution, makes sweeping generalizations about Mr. Zimmerman based on limited information, and contradicts those conclusions. Pretty harsh statement.
I think it is sworn to and accurate with everything that we said in that motion based upon a review of the evidence and the judge's order.
Yeah. So where does that go from here in terms of the judge and the potential removal? Because
the rule is sort of clear. What the rule says is that if we file a motion that suggests just that we believe the court may be biased against my client or prejudiced, and that he would not, to the extent that he would not get a fair trial, then the court has to look only at the four corners of that document. If it's sworn to, the judge, under the rule, has to believe that the facts within it are true. And if those facts are true, do they give a reasonable belief that my client would not get a fair trial? He is not to go underneath the facts of the case, which is why, honestly, I wouldn't want to comment more on it, because he is to rely just on that document and nothing else.
Okay. So you feel he went beyond the document and the comments that he made about George?
I'm sorry, let me back up a little bit.
Sure.
My motion that is now pending before the court is a sworn motion by George, and I've attested to it to be in good faith. Judge Lester is to consider only that motion in deciding whether or not to recuse himself. And that's all he is to rely on.
And obviously the state is put forward their motion not to have that happen. So that
I don't believe that the rule allows for the state to respond. I think it's very clear that the judge is to decide immediately, not more than 30 days, on the face of our motion.
Let me go back to the issue of the change in bond and the financial situation. There was a period, I think, of 4 days from the time that George was given a $150,000 bond, and then you brought it to the court,
yes.
is my understanding. The fact that, wait a minute, there is more money here. And that really angered the judge. And that brought into the issue his wife and his suggested that in effect that she be brought up. He's suggesting she be brought up on charges.
And she now has been.
And she now has been. And the court making that suggestion and potentially more charges for George here as well.
Yes.
What can you tell us about that aspect of what's happening in the case?
Well, unfortunately, I think it was overblown. If this was a case where George had taken the money, hidden it, and 2 months later it was all found out about and he was buying cars or something, I can understand the court being extraordinarily frustrated. And I think that was an intentional occurrence that has no explanation. The way this thing happened, and I'm not trying to offer more excuses, but the George Zimmerman, who I had known at that point for a week, was a George Zimmerman who had been thrown out of his house, his neighborhood, his job, his wife's out of school, his mom and dad and their Alzheimer-ridden relative out of their house, tells the police everything that they want him to tell them, has to go into hiding, comes back voluntarily, is given the largesse of donations that's there, and doesn't disclose it for whatever reason.